been dealing with a pinched nerve in my neck, and the other day I was in a car accident and somebody hit us from behind, and their insurance company contacted us, and they asked if I had any injuries, and I told them that I was already dealing with a neck injury, but I've been having increased pain in my neck since I was hit from behind and my head, got jarred. And so they offered me $1,000 and if I would sign a paper releasing them. And I thought, okay, and I was going to sign the paper and so forth, but I have not signed anything. But I've had time to think about it. I'm wondering whether I should do that or not.
Thank you for your call, Ann. And I mean, I've heard this conversation so many times on here, I feel like I almost know what to tell her, but I'm going to let the experts talk.
Well, and I mean, it's a tough situation you're in. The good news is in Mississippi, we do recognize what's commonly known as the eggshell skull doctrine, which means you take a person as you find them. So the insurance company has to take you as they find you with a pinched nerve. And if the accident can be shown to have aggravated that condition that you have, they're responsible for the aggravation. Now the question is the pinched nerve something that you've been dealing with for 10, 15 years and it's just something you live with? Is there a treatment for it? Is there a cure for it? Did it make it to a point to where you're going to require surgery to fix that nerve? Those are all questions that have to be answered to determine what the value of your claim is. Is $1,000 enough? It very well may be. Is it not enough? It's unknown right now. You really need to have a medical opinion on that situation to know what the extent of your damage is on that nerve and to what extent the accident aggravated it.
Now, actually, I want to go back to just the initial phone call. It looks like she shared a lot of information that she probably should have, maybe at that point.
Well,
talking to someone
you're talking about talking with the insurance
yes,
company. Lorelei, why don't you chime in on that and kind of say what you recommend to potential clients?
Yeah, I mean, the truth is what it is, I think, and kind of like we would tell a criminal client, anything you say can and will be used against you, and that's kind of how I would approach it with one of our clients, is that less is more in this situation, but to always tell the truth. And this may have been something that if you did decide to pursue a lawsuit down the road, it's going to come out. All of your medical records are going to come out. So I don't
so
think
she was okay with just, just maybe a little okay. Okay.
She's okay, and that brings up, I don't think we have a phone call right now.
Yeah, we go ahead.
That brings up a very important point with pre-existing conditions is when you do have a lawsuit, you need to be completely forthcoming with your attorney about prior injuries. For example, let's say you injured your knee in a car wreck and you had knee surgery 10 years before that for some other condition. You need to let your attorney know that, because when they go to take your deposition and ask you questions under oath, if you don't disclose that prior knee surgery from 5-10 years ago and the defendants find out about it and they feel like you hid it from them, your whole case can be dismissed and you have no recovery whatsoever. So it's very important to put your full medical history out there, let your attorney deal with it, and let him address it through the legal system as opposed to trying to maybe not disclose it for him.